Social justice means applying the law equally to all people, but in practice, that doesn't always happen. I'm John Gonzalez. I'm here with my law partner, Jack DeRora. We practice law, we seek social justice. On this show, we reveal the conflict between the two.
You know, for a while, it was just us in the office over a cup of coffee talking about the news of the day. With social justice issues dominating our culture, our focus became, how do we as lawyers make a difference?
And now it's not just us. Actually, it is today, isn't it?
It is just us. Yeah, that's a change.
We're going to talk about the United States Supreme Court, and if we have time, Jack, maybe about the Ohio Supreme Court. The thought being that if this was Vegas, they probably wouldn't put much odds on how a justice is going to rule on a case, because you pretty much know by their political affiliation whether they're going to come down on a conservative side or a liberal side, right?
Yeah, pretty much we can. That's right.
And I found an article that I alerted you to about this Missouri case involving Marcellus Williams. And what happened in this case is that basically he was convicted of murder. And the case was before the Supreme Court to stay his execution because there was a lot of problems with the case. In fact, there was, according to the article, a startling lack of evidence, racial bias at trial, and basically the United States Supreme Court, in an unsigned and unreasoned order, with all three liberal justices dissenting, let him be put to death. And the article talks about a little bit about the case, which is shocking, but more about how the Supreme Court, United States Supreme Court, in other cases, bends over backwards to justify, in effect, saving the defendant, i.e. Donald Trump in the immunity cases. And then it also talks about the January 6 cases, that the conservative judges go out of their way to find legal reasoning that strains the bounds of common sense, in the author's opinion, to kind of let these people off the hook. Yet here you have a black gentleman who didn't get a fair trial by all accounts, and they don't really seem to care.
Well, you're leaving out a couple important facts. First, it was the prosecuting attorney from that county who decided that the execution should be stayed. That's pretty significant. Plus, we had the family, the survivors of the victim, saying, we're not interested in executing this man. So it all goes to show that here's the Supreme Court faced with everybody contending that this is a breach of justice and just not really getting concerned, which speaks to, aside from many other things, just the fact that the court is concerned only with process. The process happened. It didn't appear that bad to the Supreme Court, and so the court didn't get involved. But you're right. When we compare that with the Trump decision and giving Trump immunity, and there was nothing, literally nothing in the Constitution that talks about presidential immunity, it really makes you question where the court is.
You and I aren't judges. We don't know what consternation they may have about their decisions. But when I look at something like this, my thought would be, if I was a U.S. Supreme Court justice, here is a case that screams out for justice. And there are a number of precedents that the court could have relied upon to save this gentleman. One of the things that the article points out is that he was accused of murdering a white woman, and the prosecutors struck 6 of the 7 prospective black jurors. As you know, that's unconstitutional to do that.
Right.
And the court could have, on that basis alone, have thrown out the conviction. But instead, they let basically an all-white jury decide the fate of this gentleman in this day and age, which to me is just incredible.
And let's remember for a second that putting somebody on death row who is innocent is not necessarily, or let me rephrase it, putting somebody on death row who doesn't belong there is not unusual. We know of at least 6 men in Ohio who were exonerated from death row, not because of some evidentiary or procedural matter. They were exonerated. So what does that tell you about the problems with death row and executions in general?
The other thing, too, is that at this point, the justices were just asked to stay.
Mm-hmm.
It wasn't, hey, you have to decide on the merits. Can you just pause this proceeding so that we don't have an issue of possibly
killing the wrong guy,
or killing an innocent man? And they couldn't be bothered to do that. And again, the couple of the points the author made that I thought were interesting is that you take the January 6 cases. They bent over backwards to throw out one of the indicted offenses in that because of the potential, and I think it was a theme that ran through the immunity case, the potential for prosecutorial misconduct. And here in this case, there was claims of prosecutorial misconduct that, again, the court, as the author points out, couldn't be bothered to just stay this and have these issues looked at with a little bit more scrutiny.
Makes you think that those 6 conservative justices are the kinds of people who just never got their hands dirty, never had to deal with the difficult aspects of life, including what it's like to be low income, prosecuted, no attorney, poor defense. No sensitivity to that. I think it's striking. And you've really made a good point. They weren't asked to exonerate this man or vacate the judgment. They were just asked to hit the pause button. Couldn't be bothered.
You know, I've come across this in one of my cases. As you know, we had a gentleman that had been convicted of rape, and the evidence at trial over the years just fell apart on the prosecutor. The DNA didn't hold up. The eyewitness recanted. A lot of issues in the case. And let me tell you what, proving those issues is hard after 20, 25, or 30 years. And the prosecutors, they just held fast to the notion that he was guilty. And it wasn't even the prosecutors that prosecuted the case. These are prosecutors that came along later in life.
20 years later.
Yeah. So I never really understood the animus towards this particular defendant.
Well, it's not an animus toward the defendant. It's a reticence, a reluctance to confront the fact that the system is flawed. And I can't remember the name of that gent who we had on the show a couple years ago from the Innocence Project in Cincinnati. Oh, forgive me for forgetting his name, but that was a key element in his book. People don't want to confront the fact that the system is flawed.
Well, then we go back to our Supreme Court justices, and listen, you and I are patriots in the sense that we love the judicial system in America. But we're realists too. We understand that there are flaws. And I don't think those two have to be mutually exclusive. I think you can recognize that the system is a really good system if it's done right and if the right people are in charge, and also be able to say it's not being done right here. Let's tweak it, right?
Let me add to your comment about being a patriot. I don't think you're a patriot if you have blind belief in the system and are not willing to look at it critically.
So is it a problem with our justices living in a bubble where everybody looks like them, everybody acts like them? I mean, I say that with some hesitation because, obviously you got Clarence Thomas, black justice. who seems to enjoy the wealthy life with white people and is very conservative. And a lot of criticism of Justice Thomas is that he has forgotten where he came from, which was a very modest, poor beginning. And that he doesn't have that empathy anymore for a guy like this that was taken through the system and treated unfairly.
Well, Justice Thomas may have forgotten where he came from and may have lost that sensitivity. It's possible, right?
It may be. Now, I think you and I have different feelings about political bias and how it may influence judges. I think you had told me that now in Ohio, judges are elected. Judges to our Supreme Court are elected, and they have the political affiliation, and you're okay with that.
Well, first of all, I don't like our system at all. I don't like the fact that we vote for justices or judges. I'm okay with the fact that we put their party affiliation on the ballot because that's the reality. They have to be aligned with the party. They need the party backing. So why not be transparent about that? The bigger problem is that we are electing people who are not always up to the job, but they know how to get elected. That's the problem.
And to bootstrap onto that idea, I like elected officials and judges. I do. I think that's a better system than an appointed system because I don't know of an appointed system that's more fair. Now, if we could have an appointed system that was fair, I'd be all for it. But we don't. But you know who chooses our justices and our judges? The parties. The parties run two people, and we have to decide which one we're going to support. And those two people are going to be party loyalists, right? You're not going to run for the Supreme Court of Ohio on the Republican ticket if you're not a good Republican with conservative credentials. You're not going to run as a Democrat unless you are a good Democrat with Democrat credentials. So we end up with this system where the parties are choosing, and I guess we shouldn't be surprised that when it comes down to it, the political tendencies come through, right?
Well, no, we shouldn't. And I don't want to dwell on this too much because I think we've talked about it a lot. We could go into a long discussion about why I still disagree with you about elections being inferior, or I disagree with your point that elections are better than a selection system, but that's a whole nother discussion. And both are significantly flawed, don't get me wrong.
So back to our justices on the Supreme Court in this article that I really love. So the author says here, the conservative justices don't bother to even hide what's going on here. This bigger picture of the way they're ruling. When they gutted the Clean Water Act in 2023, allowing wealthy landowners to destroy crucial wetlands, they had the gall to root its decision in due process. And he quotes, "A staggering array of landowners are at risk of criminal prosecution or onerous civil penalties," the court fretted. The environmental protection at issue conflicted with the Constitution, it reasoned, because their definition was too vague, encouraging arbitrary and discriminatory enforcement. Apparently, the straightforward mandate, "don't destroy wetlands without a permit," flunked the court's test of due process, but the execution of innocent person does not.
Oh, yeah, it's really a stunning and harsh evaluation of the court, but rightfully so. So there's another case mentioned in that article. It had to do with bribes. It was called the Snyder case. It was a mayor, I think, I can't remember, maybe it was in Pennsylvania. He was accused of taking gratuities for steering $1 million contract to the city. So the question is, well, was this a bribe or was it a bribe? in violation of federal statute. And basically what it came down to was the Supreme Court said, yeah, okay, he got gifts, he got money, but it came after the contract, so it couldn't have been a bribe. Well, maybe technically that was the right reading of the statute, although I'm skeptical. But it does go to show that if they were deciding a case about some low-income man who committed a crime, I don't know if they would have worked so hard to find that the person was not guilty. We really do have this rigged system where people of a certain class get treated better than people in another class. And let me skip to a non-Supreme Court to make that case, and that deals with Jeffrey Epstein, right? Mm-hmm. Jeffrey Epstein was indicted for having sex and trafficking some 36 young women, a lot of them teens. The deal that was cut with the U.S. attorney in southern Florida was that he would get 13 months in a county jail and he could go to work during the week. That U.S. attorney landed up, I think, being Trump's Secretary of Labor for a while. Now think about that. If that person had been a man of color and had been accused of the same crimes, he would have been allowed to go to county jail for 13 months instead of facing trial for what might have been a life sentence. It just doesn't happen.
There is another case that the Supreme Court was wrestling with. And again, is a gentleman on death row that they ended up taking. And I watched a little bit of the oral arguments. And it was Gossip versus Oklahoma. And it's still pending. There hasn't been a decision.
Oh, right. It's basically like the Marcellus Williams case, isn't it?
It is, but I don't think the victims were on board with the exoneration because, and I only picked this up from watching the oral arguments that they had presented a counter brief. But watching the questions from the court was incredible. It's, you ever hear of a soft pitch in softball,
tossing them grapefruits.
Sotomayor says, basically walks the lawyer for this guy through the arguments, and all the lawyer is saying, yes, that's correct. Yes, you're exactly right. Yes, you're right. But then Alito and Thomas take them through, to your point, very technical procedural stuff and can't understand why this case is even before them because on a procedural technical basis, this guy doesn't get a new trial under any, which again leads me to my experience with even state law and certainly federal. There are so many procedural impediments to reversing an injustice. And it seems to me that courts can go either way because we still give judges a lot of discretion. And just to hear the conservatives on the court just want to talk about the procedures. And I was pretty impressed with the lawyer for Mr. Glossop. He was pretty good at countering the questions. And a couple of times he would say, with respect, Mr. Alito, with respect, Mr. Thomas. And he would correct them or he would come up with a point that I thought was pretty good. And I thought that when the justices were losing an argument, they would cut him off and move to something else. But it was very interesting to listen to it. I've argued in front of our Supreme Court a half dozen times, and it's a good discussion. I think these justices, for the most part, get into the cases and understand them. And certainly Alito and Thomas and the liberal justices all knew the facts. And the questions were good and the lawyers were good. So you get a sense that our system procedurally is working just fine. But then you start to listen to the justices and you just know where they're probably going to come out, unfortunately.
Well, as I said before, much more value is placed on procedure than getting to the right result. In fact, I said this before on another podcast. It was Justice Scalia who said the Constitution provides you with a right to due process. Then he went on something to the effect of, but it doesn't guarantee you the right answer. So sorry for your bad luck if the procedure fails you. As long as we have substantially met the procedure, that's all we're obligated to do, as opposed to having, I hesitate to use this word, a more holistic system where we're concerned about the right result. And I don't know the background of those 6 conservative justices, although you've suggested that Thomas came from humble background. But I wonder how many of those Supreme Court justices did volunteer work, worked in the inner city, rubbed elbows with working people, had to deal with pro bono cases, had to deal with people who couldn't afford an attorney, really got their hands dirty, as opposed to being government lawyers in the upper echelons of whatever administrations for so many years.
You know, when you think about that, those life experiences, I'm not sure in my mind that it matters that much. Certainly, we've met people on our podcast that were in the upper echelon of some of these law firms that are now doing nonprofit work and probably didn't grow up in that atmosphere with the people that they're helping. And then you have, I'm sure, although I don't run into it very often, those folks that have an experience and it just turns them off to poor people or to uneducated people that they just don't want to give them a break. I mean, I've had friends of mine talk about, why are you giving that person money? Mm-hmm. Social welfare, money.
Right.
And then at the same time are ready to put their mother's entire estate into a trust to keep it from Medicare so that they can inherit it and the government can take care of their mother. Right. Which is legal. Don't get me wrong. And we do it as a law firm. We do that kind of work. But it just, to me, is like, well, wait a minute. How come you can get government assistance for your family, yet you're arguing that these people shouldn't?
Well, you've pointed out some things that show that maybe a background isn't as important as I might tout it. But what I'm really trying to get to is you need people who have a breadth of experience and are willing to entertain new ideas. Now, that's pretty hard to do. It's pretty hard to find that person. And as a consequence, most people are operating subliminally. I don't think justices think, oh, I'm supposed to vote this way because I just think it happens. They're not even aware of it. Just like you, Gonzo, know how I'm going to decide things. Mm-hmm. Right? You'd be willing to make a sizable bet on how I would decide a certain proposition just because you know the way I think. They're no different.
They aren't. And what makes you different a little bit from this process is you will at least listen to the counter argument, and not just listen, but think about it and decide whether it's true or not. My neighbor was all excited about the prospect of his overtime not being taxed if Trump gets elected. Mm-hmm. And I said, but at the same time, you're complaining that Kamala Harris is going to give first-time home buyers money to buy a house. I said, how is this any different? Other than the government's benefiting you and not benefiting someone else. And he has no answer to that. And I try to tell him, look, I'm not judging your position in a sense. Just own it. just listen to what you're saying and own the hypocrisy if it's there, then I at least would have a little bit more respect for your position. Let me give you a quote and see if you know, and I don't expect you to, who this came from. And let's just start with, is this an R or a D? Mm-hmm. I think it's kind of humorous to watch. When the other side can't win, they want to change the rules, whether packing the U.S. Supreme Court because they don't have the justices they like.
Had to come from an R.
It did, but I also think that the D's, you could be talking about a D, right?
Oh, sure, FDR in the 30s.
Yeah, I mean, it's changing the rules to win, right? So that's by a gentleman who's running for Ohio Supreme Court, Joe Dieter. Now, I don't know if you remember, but Joe Dieter was appointed by Governor DeWine to his current position.
And also a firm advocate of the death penalty.
And he is basically saying, I'm an R, and I think the D's are going about it the wrong way.
Oh, yeah.
Completely ignoring the fact that for, at least 2 decades, the Federalist Society has been putting conservative justices on the federal bench just because they didn't like the rulings that they had before. I also think that gerrymandering is a way to change the rules. And that's what he was talking about, gerrymandering. That issue 1 is the way that the Democrats are changing the rules because they don't like the results. And I thought, how funny it is, I think hypocritical to think that way. But he's thinking like an R, not like a judge.
Yeah, exactly right. And the technical flaw in his argument is that issue 1 certainly is trying to change what's happened in the last several years, but it's hard to argue that it's doing it in anything other than a neutral fashion.
Here's another quote. The Ohio Supreme Court upheld the ballot language for the most part. There were a couple areas they wanted it changed a little bit for the most part. This decision is a huge win for Ohio voters who deserve an honest explanation of what they're being asked to decide.
That's either Frank LaRose or Matt Huffman.
It's Frank LaRose.
Yeah.
And I think I've told you that I like Frank LaRose personally. He wouldn't know who I am, but he knows my wife, and he seemed like a solid guy when he was in the legislature.
He was.
And I just sometimes scratch my head, but I do understand politics is a business, and to get ahead, you got to take certain positions. But this language that they're using.
Oh, it's horrible.
It is. Now, that wasn't his language, though, right? There's somebody else that proposed it. Was it a state legislature?
Yeah, that was Teresa Gavarone.
Yeah.
I think I'm saying that correctly. Gavarone or Gavarone.
Yeah. And so what is the idea that that gerrymandering is...
You can't explain it because what they've done doesn't make sense.
Well, let me ask you this, because I know you've written on this and published, and what I think I'm hearing is that the new commission will have to gerrymander these districts to fit the Constitution, as opposed to our Republican leaders who are now in charge of it gerrymandering it to not fit the Constitution. It's going to be gerrymandered no matter what, right?
I mean, actually, the way the Republicans use the term gerrymander is inappropriate, because gerrymandering, by definition, I think, is convoluting the process and taking fairness out of it. So they're trying to make it sound like issue 1 will result in unfairness, when it's really designed to promote equity.
Yeah, these districts aren't drawing themselves.
Right.
Nobody is going to be there. Somebody has to look at the data, look at the fairness in the way the Constitution requires it, and put them together. It's only gerrymandering when you're doing it in a dishonest or disingenuous way.
Right. Well said.
Yeah. And so back to Dieter's, I think it is kind of humorous to watch when the other side can't win. They want to change the rules, because I think the Republicans understand that if these districts are drawn fair, they may no longer hold the power they hold.
Right. And I think the folks behind issue 1, they don't take this as a partisan act. They want the same set of rules no matter what for everybody.
And again, I argue with my beloved neighbor about these issues because he's a no on issue 1.
You know, when you talk about your neighbor, I have this vision of like Tim Allen's old Tool Time, you know, where there's the guy with the fence and you just see the crown of his head and the hat and dumb words coming out of his mouth.
We have an interesting relationship, though, because most of our disagreements are just in text messages. But when we're together, we hardly ever talk politics. We just have a lot of fun.
Oh, okay.
He's a very interesting person and actually a dear friend, which helps me sort through some of my thoughts on these issues. But again, you know, I ask him about all of this fraud that apparently he believes happened in the 2020 election, and then it's going to happen in 2024 to possibly keep Trump off out of the presidency. And I said, well, then why aren't you for issue 1? Because doesn't issue 1 take out any of that type of shenanigans? They're drawn fairly by non-politicians so that we can have fair elections, which, if I hear you right, we agree we should have fair elections. But no, he's one of these people, Jack, which takes us around. Weaving now, like President Trump, you know, that feel like Republicans good, Democrats bad. And so if a Republican wants it, he's for it.
It's got to be good.
Yeah. If a Democrat wants it, no, it's got to be bad.
Let's get back to our discussion about the Supreme Court, especially the U.S. Supreme Court. And you've said what I've said, which is they just seem to live in a bubble on a plateau above the rest of us. You know, the realities of their decisions or the ramifications aren't anything they're concerned about. They're just hyper-technical in their approach to life. But there's something else that goes on with them as well, and that is they really do see themselves as separate and apart. And I think we touched upon this some weeks back, but I think it was 6 months ago, 8 months ago, some of the people in Congress were saying, don't we need a code of ethics for the Supreme Court? Because there's a code of ethics for everybody else in the world. And it was Alito who said, well, I don't think Congress has the right to do that. I don't think Congress has the authority to promulgate rules for the Supreme Court. I don't know constitutionally if Congress does have that right or that power, but that sure as hell isn't anything I would have said because it just smacks of hubris, right? It's a bad look. And you have to wonder, well, why wouldn't a group of judges want to live by some code of conduct? I mean, you and I as attorneys do, trial judges do, et cetera. What makes them so special that principles in writing don't pertain to them? How does that happen?
Well, I agree 100%. And I think the devil in all this is Congress. Think about it for a minute. If Congress was doing its job, being a co-equal branch of government, and a justice, put aside for a minute, Republican, Democrat, was doing the things that cause us to be concerned about their ethics, Congress could act, right? One, they can impeach them. They can have hearings. They can put a lot of pressure on the Supreme Court to be more transparent, to have a code of ethics. Whether they can do it constitutionally or not, right, we can set that aside. But if Congress could act as a independent body, and it goes back to, you take the Clean Water Act. You know, listen, what's that decision? 100 and some pages. I'm not going to go through it. If the justices, after studying it with all the brilliance there is up there, decide that it's not written correctly to do what it's been doing, who am I to argue that, right? That's our system. But it goes back to Congress to fix it. because Congress wrote the act. And our Congress, Jack, does nothing anymore of any significance because they are so paralyzed by the politics. And, that bothers me more than anything. And I used to be a big proponent of more power in the judicial branch because I used to see these decisions were like, it's up to Congress. We're not going to do anything. It's up to Congress, right? I'm like, well, why not?
Right.
Now I'm thinking it's really swung to the point where our judges have so much power, and even at the local levels, but certainly at the Supreme Court level, they have so much say over social issues in our society.
As much as I wanted to get away from the subject, I'm going to go back to the flaws that exist in elections and in appointment. In election, the flaw is we're voting for Republicans and Democrats, which is inherently a bad idea for that reason. And for the second reason, anybody can run for common pleas court or municipal court judge. You don't have to be a very good lawyer. You just have to have been a lawyer for, I think it's 6 years, maybe 7. So you can be a lousy lawyer and be elected as a judge. On the flip side, when we get to the appointment system in the federal court, as opposed to having some sense of objective data, what do we want of this person? Politics enters not through votes, but through the appointment system and what we're hoping to have in a judge as opposed to what we should have as a judge. Now, both systems could be fixed within themselves. You could set criteria. You could do things differently. But once again, nobody likes changing the status quo. We like it the way it is because it favors certain people, and those certain people have power.
I sometimes think of the military hierarchy because that changes out pretty.
Oh, yeah.
Often, right?
Yeah, tour of duty is somewhere between 2.5, 3 years generally.
But if you're on the Joint Chiefs of Staff or you're up there, at the very top, they're not lifetime appointments.
That's a 2.5, 3 year term. Colin Powell. Mm-hmm. Everybody loved Colin Powell. Nobody had anything bad to say about Colin Powell, but his term had a finite life.
So to be appointed to the federal bench, the trial bench, or the Court of Appeals, we do have committees. Right. And I've been through that process, and I was pretty impressed. They vet, they look at a lot of stuff. The committee has a wide range of people on it. Now, there's a different committee if the Ds are appointing than the Rs, but the people on the committees seem to be pretty ethical, pretty robust. I like the process. Mm-hmm. Trump bypassed those committees for his appointment. But those committees then only made a recommendation to our senators who then could either accept or. But for years, our senators accepted the committee's recommendations.
And the ABA, the American Bar Association, had a lot of sway in those nominations. Mm-hmm. And guess what? A lot of the people that were nominated in the last few years prior to the Biden administration didn't pass the ABA scrutiny.
So I kind of like your idea if we had the right type of a committee, mm-hmm. maybe like this Issue 1 committee to draw fair districting lines. We need the right committee. And then I would say, listen, we don't need judges appointed for more than, say, a decade. That's a long time to be a judge. And there's a lot of sharp people coming up behind them. So it's not like they're the only person that can do that job. I would like to see that as opposed to voting because let's face it, the voters just don't know enough to make a wise choice.
They have zero clue. In fact, the non-litigator lawyers in Franklin County have no clue as to which judges or which judicial candidates are strong.
Yeah. Jack, as always, it's great talking to you. And the only thing missing right now is a cup of coffee, but it's always enjoyable.
As always, I enjoyed talking with you, Gonzo. We'll be back in another week or so with another important social justice issue. Until then, if you like what you heard, Tell a friend we want it to be more than just us. So long.